preliminary report for the eyes of their instructing solicitors and the parties only, and before they prepare their main report, there is a meeting. It may well be on site, and the purpose of that meeting is essentially in a sort of almost a collegiate fashion amongst the experts to identify what the grounds of the dispute are. And when they have identified what they agree, and they set them out, when they have identified what they disagree on, they put only very brief reasons in the joint memorandum, and then the report that is disclosed to the court is prepared thereafter and concentrates only on the issues upon which they have disagreed. Now it's a different way of doing things to the one that I'm familiar with, but I assume, at any rate, because I don't have the experience, I assume that it works much better in the sort of wide-ranging field that you encounter in a building dispute, where you're dealing with events that have taken place over many months, and there are all sorts of disputes often between multiple parties about what went wrong in the construction of a particular item or the like, and the experts at that stage are meeting at one of these meetings, again under the same rules and constraints about having without prejudice discussions and not being bound by anything until it's put in the meeting, in the memorandum. But I can see in that context the sort of instance that you're describing could arise, but ultimately, if a party is going to rely on something to persuade a judge of it, it is going to have to be out in the open, and if it's not going to rely on it to persuade the judge, then you don't need to worry about it.
Can I just ask, I don't know if it's pertinent now, as it seems in sort of personal injury cases, what if an expert, I suppose I'm trying to reconcile the consultative role, advisory role, but then when it goes into court, when one has so as an advisory role, one may be shown a report by another expert of a different field, and then comment on whether perhaps this expert feels the report is helpful or not helpful. And then the instructing solicitor might decide to rely on the report or not. My understanding is that if one has seen a report by different experts, because it's not being relied on in the case, one does not have to refer to that particular report. So I suppose that it's not a conflict with them being impartial to the court.
No, your duty is to give your opinion. If you happen to have read something that was contained in a report that changes your opinion, then it has changed your opinion.
But if it's not relevant to one's opinion.
But if it's not relevant, then you can put it out of your mind. That brings us to the other last resort. If having asked your instructing solicitors for guidance, you have not found satisfaction, you can always go to the court. Now, it very rarely happens in my experience. I think I'm trying to recall an occasion, I can't recall an example of an occasion when it has happened, although I'm aware of occasions when it has. And what tends to be the impetus for it is that there has been a falling out, essentially, between experts at the meeting. One, perhaps you're obviously not as being recalcitrant, is insisting on, as in the example you gave, including within the joint statement all sorts of what you consider to be improper stuff which has no business being there. If you cannot sort it out between yourselves or with the assistance of your instructing solicitors, then you are permitted to go to the court and ask the court for guidance.
I'd just add to that, be very careful with it, because if the judge doesn't agree that it happens to be a worthy question to worry the court with, you're likely to get a fairly robust response.
Thomas reminded me in our discussions of another, of another, this is not experts asking questions of a judge, but of a jury asking questions of a judge. And you may recall the Vicky Price and Chris Hoon case, where after 14 hours of deliberation, the jury came back with a number of questions, the most remarkable of which I think was this. Can a juror come to a verdict based on a reason that was not presented in court and has no facts or evidence to support it, either for the prosecution or the defence? He did ultimately discharge the jury.
He decided he was never going to get a reasonable trial out of them.
Yeah.
But, you
So
know,
you-
if 1 in 20 of the British population are challenged intellectually, there must be occasions where you saw 12 people and they all happen to come from that bottom decile. I think this must have been one of the cases, but I hasten to add, I know none of the jurors in question.
Pitfalls. Sorry.
So, getting back to what the gentleman there was saying, that back to asking the court, if you believe the other side has carried out some experiments or done something, can you actually ask the court to force them to disclose the results or what they have done?
Well, I'm wondering about that. I mean, I think the short answer is probably not, because the discussions that you have between you, in which he has revealed this, cannot be referred to at court without the permission of all the parties. So if he's telling you about something that he's done which is not ultimately going to be relied on, then I think you just have to put it out of your mind. He's not told you anything useful after all, because he's kept that to himself. I think I would. I mean, it's slightly difficult to talk in generalities about these things, and I think that a specific example might produce a different answer than what I've just given, but I can't at the moment think of what that specific example might be.
I'm just thinking, on the construction side of things,
Yeah.
I'm just thinking, say the other side did some tests, and oh my goodness, when they did the test, they failed, so therefore they just looked back to the side and pretended it never happened.
No, I don't think that they would be. If they're doing tests during the court as a result of the litigation,
Yeah.
then the tests that they do are privileged. Anything that they discuss with their lawyers, or the tests that they do, they're all privileged. They don't have to reveal them, and so you wouldn't be able to force them to do so.
Certainly in my sort of cases, to pick up on the point, the legal system works by both sides being able to put up those arguments and those examples that fulfill their side of the story and back up their side of the story. And in the same way, you cannot force somebody else to actually, on the other side, to reveal something. They may not wish to, but that leaves a void. And therefore, the judge will normally be able to make a decision that one side have got n number of tests and supporting arguments to their point of view, and the other side say, well, we just think we're right. And you can imagine which side looks weaker in that sort of argument. Does that deal with it sufficiently?
Yeah.
Yeah.
Yeah, you mentioned when both experts agree that there needs to be additional issues introduced and addressed in their joint statement. Presumably that's restricted by issues of costs and to the degree you go sort of off-piste with issues that you haven't been asked to address in your instructions.
Yes, I mean, if you consider that there is, in order to test the difference of opinion between you and your opposite number, that there is a test that could be performed, then identify it, and it'll be for the parties to decide whether it's can be done at proportionate cost.
In fact, it will be a very nice point for the experts to agree that an additional test should be carried out.
Right.
And if that requires additional time, the solicitors will be able to go to the judge and say, the experts say that this needs to happen, this is part of their memorandum, they've agreed on it. Yeah, we don't want to do it on the basis that it's going to cost too much.
Yeah.
But essentially, you have done your professional duty, which is to say, to form a conclusive view on this, we need to do a specific test.
Sounds good.
Sounds as though you've been professional then.
If an expert persuades you that perhaps your opinion might be wrong, and you have to significantly change it, could the person that you're working on behalf of then turn around and say, you know, you've wasted a lot of money, we're therefore going to sue you?
Well, we'll come to that. It's one of our pitfalls. Okay, and to avoid falling into any pitfalls, two things are absolutely vital. The first is only accept instructions in a field in which you have the appropriate level of relevant expert knowledge and experience. If you accept something which is slightly off your piste, then you are asking for trouble, because you may express an opinion which you are then persuaded out of by someone who is expert in that field where you were not. So that's one way to avoid that happening. The other is to ensure that when you prepare your report, you prepare it thoroughly, you conduct appropriate level of investigation, and you do a proper literature search before you express opinions. And when you come to the joint meeting, you come to the joint meeting well prepared. As Thomas says, you make sure that you have reread your report and any supportive material that you sent with it, that you've considered all of the available evidence in the case. And one thing that I suggest in the paper is a good idea, in some cases at any rate, is it's sometimes helpful for you to have a bundle of the relevant documents available to you at the joint meeting, which is agreed between the parties as a bundle and is paginated, and that you can each of you then refer to. And that can say, first of all, it ensures that you are working from the same evidential material and things are not left out and forgotten. And it also saves time because everything is there in a single place and can be located simply. But you ensure that you are well prepared, you've considered all of the available evidence, and the good practice, as we've suggested, is for an agenda to be prepared. And before you go to the joint meeting, best practice is almost certainly to go through that agenda yourself and to answer to yourself, possibly in writing in a draft, what your response is to each of the items on that agenda. And if you've done that, you are going to be much better prepared than if you go in cold and find that you then have a discussion with the other side, which when you see his version of the joint statement, you think, it's not quite actually on reflection what I do think, then you have to go back on things.
I've thought of one thing. The gentleman in the tartan jacket who asked about an additional test or something like that the experts believe is necessary. I would try and always push it back up the line. In other words, when you actually do your report, think through what tests, etc., could be done in that situation. Because if you can identify them at that stage, it makes it much easier when you come to the experts meeting.
Yes.
Now, inevitably, sometimes things go off in a different direction, and there will be tests that perhaps you will want to do after the experts meeting. But you look much more professional if you've identified peripheral topics that perhaps could support or would help the court come to a decision if you've done that originally in your original report.
Okay. Can I just add something to what David said? You talk about going through the agenda and writing in your own responses. I'm sure that's